You know, when you live in a community with an HOA, you agree to follow the rules. But what happens when the people making the rules don't seem to be following them themselves? Well, we're going to break down a real-life legal battle between a homeowner and his HOA, and it all boils down to one powerful right, the right to see the records. Let's dive in.
So let me ask you this. What can you actually do? You pay your dues, you mow your lawn, you follow all their rules, but when you ask a simple question, the board just gives you this silent treatment. This isn't just some hypothetical, by the way. It is the absolute core of the case we're looking at today.
All right, so let's meet our players. On one side, you've got Jeremy Whittaker, a homeowner, and on the other, the Val Vista Lakes Community Association, the group that governs his neighborhood. And what started out as a pretty simple request for some documents, well, it quickly spiraled into a full-blown legal fight.
So how did this whole thing even start? It wasn't some big dramatic showdown on a lawn. Nope. It all began with a couple of simple written requests for information, a right that is literally granted to homeowners by state law.
Okay, check out this timeline because it really shows you how things went off the rails. The first requests go out in late February and March. Now, the law says the HOA has just 10 business days to respond. 10 days. But a final decision from a judge didn't come down until August. That huge gap, yeah, that's where our story gets really interesting.
So, that first request on February 27th, it was all about how the HOA runs itself and how it spends money on lawyers. Whittaker asked for the official policies, the meeting minutes, and, this is the big one, all the documents tied to the association's law firm. He was pretty much asking, hey, how do you operate and how are you spending our money on attorneys?
About a month later, he followed up with a second request, and this one was even more direct. This time, he asked for the official, honest-to-goodness bank statements for all of the association's accounts. We're not talking about some summary report someone typed up. He wanted the raw data straight from the bank.
And what did the HOA do? Well, according to the court records, absolutely nothing. No documents, no emails saying we're working on it, just radio silence. And it was that silence that took this from a simple request for records to a formal legal battle.
Okay, this is the point where things get really serious. See, when an HOA doesn't follow the law, homeowners actually have a way to hold them accountable. The whole dispute moved out of emails into the courtroom, or in this case, the Office of Administrative Hearings, and the legal games began.
So even before the main event, both sides were already in a legal chess match. Whittaker, the petitioner, got his two cases combined into one, a win for him. The HOA tried to get the whole thing thrown out, but the judge said no. They did succeed in blocking some of Whittaker's document requests, and his attempt to get their lawyer disqualified also got denied. So you can see it was a real back and forth from the very start.
All right, after all that preliminary maneuvering, the case finally gets its day in court. This is where both the homeowner and the HOA get to stand up and tell their side of the story to the judge, explaining exactly why they think they're right. And here's what it all boiled down to. The homeowner's argument was super straightforward. The law gives you a 10-day deadline, you blew past it, and you should be penalized. Simple. The HOA's defense, a lot more complicated. They claimed the law itself was outdated and misunderstood, that their internal policies were just trying to make things easier, and hey, some of those documents were privileged anyway.
Now, this is the part that you really have to pay attention to. The HOA's main defense wasn't just about this one request. They were literally challenging the state law itself. Think about that. They were arguing that the very law they're supposed to follow is wrong. I mean, talk about a bold strategy. It's incredibly risky, because if the judge doesn't buy it, you've basically just admitted you don't agree with the statute that governs you.
And all of this leads us right here, to the climax of the story. After listening to all the arguments, looking at all the evidence, and considering the law, the administrative law judge was finally ready to make a call. This is the moment, right? The big question. Did the judge side with the HOA and agree that this law was just too old to matter? Did their complete silence actually break the law? Or was the homeowner just asking for too much?
And there it is. The judge's decision was crystal clear. He said the HOA's failure to respond was, and I quote, simply unacceptable. Not a minor slip-up, not a misunderstanding, but a straight-up violation of the statute.
And here's the really important part. The judge actually agreed that, yeah, some documents might be protected by attorney-client privilege. But, and this is a huge but, he ruled that's not an excuse to just ignore someone. The HOA should have responded within that 10-day window, handed over what they could, and then explained why the other documents were being withheld. Just ignoring the request completely? Not an option.
Of course, the ruling came with a price tag. First up, the judge ordered the HOA to pay Whittaker back for his two $500 filing fees. That's $1,000. This basically says, you made him go through this process, so you're going to pay for it.
But wait, there's more. On top of reimbursing the fees, the judge slapped the HOA with another $1,000 in civil penalties. This wasn't about making the homeowner whole. This was a direct punishment for breaking the law. It sends a pretty loud message, doesn't it? Non-compliance is going to cost you.
Okay, so a homeowner fought the HOA and won. That's a great story, but what does this one case really mean for the millions of other folks living in these kinds of communities? Let's zoom out for a second and look at the real impact here.
You know, the heart of this entire fight was this one law. It says pretty clearly that the HOA's records have to be reasonably available and that they have 10 business days to fulfill a request. That's not a suggestion or a friendly guideline, it's a hard and fast requirement. And this judge's ruling basically slammed the gavel down and confirmed this law means exactly what it says.
So, if we boil it all down, here are the big lessons. First, as a homeowner, you have a legal right to see the books. Second, your HOA has a legal duty to respond, and fast. Third, just ignoring you is in fact against the law. And maybe most important of all, this case proves there's a real system in place to back you up and enforce your rights.
And that really brings us to the final question we should all be asking ourselves. This case is such a powerful reminder about transparency and accountability. It highlights just how critical it is to know the laws that govern your own community, because at the end of the day, knowing your rights is the first and most important step in making sure they're actually respected.